Welcome to Justice at Work, Employee Rights and Protections in the Workplace.
Welcome to Justice at Work, real talk from Filippatos, PLLC, where fighting for fairness in the workplace is more than a profession. It's a mission. Each week, we break down the rights you didn't know you had, the systems stacked against you, and the legal paths that can set things right. Whether you're facing discrimination, harassment, retaliation, or injustice on the job, we're here to help you understand your power and how to use it. I'm Lisa Mosbey, and today I'm here with Parisis Filippatos, talking about severance agreements and what employers don't tell you before you sign. Welcome, Gerry. Thank you so much for joining me for this conversation today.
Thanks for having me, Lisa. Good morning.
Thank you. Gerry, what typically leads an employee being presented with a severance agreement?
Well, typically something has happened, whether it's involving the employee themselves or something involving the company that has brought the employer to make the decision to separate the employee. And most companies have either an informal policy and a written policy that they offer, some time compensation going forward from the date of the employee's termination, based essentially on years of service. So if you work at a company for a year and then you're laid off, let's say, for not a nefarious reason, typically the employer will give you probably a week's severance. It's the typical industry standard, and varies industry to industry, is a week per year of service, capping at a full year of pay. So, that essentially is what you're not entitled to it legally, but what you can expect. When we look at what the severance agreement contains, and why you have an ability to negotiate for more, if there's been something that makes you feel that you were treated unfairly, is that the severance agreement has a release typically. And the employer, yes, is doing a kind thing, I suppose, by offering you severance upon termination, but they're doing it typically conditionally on a general release where you're surrendering all your claims. And whatever offer they make to you, and especially if what led up to your separation from the company, your termination, is some kind of acrimony, they want your signature on that general release. And that actually gives you the power. You might feel that you've been disempowered because you've been separated and terminated, and that feels terrible. But if an employer is coming to you with a severance proposal, typically means that they want your signature on that release, and they've already put a value on it. And of course, they're typically not going to give you the best deal right away. You're going to have to negotiate for a better severance in return for that general release. And that's where attorneys come in.
And I didn't always know that we could negotiate severance packages. That was something I've learned recently. And I understand what you're saying. The most important piece of that is your signature, because their intention is for our relationship to be complete. We're done with it. I'm releasing you from any further obligations or complaints. But what kinds of rights or claims are usually being waived in these agreements?
Well, it's almost always a general release. And that release is for all of your claims. So let's say you were the victim of discrimination or retaliation, you complained, and then you got fired. That makes for a very strong case. Your employer, especially before you lawyer up, may offer you a severance and say, we'll give you a month of severance, 2 months of severance in return for this general release. And depending on the circumstances in the jurisdiction, an NDA, non-disclosure agreement. But the release is what's most important, because the release will prohibit you from ever bringing any claim about what happened to you on the job. That's why it's worth so much.
Gerry, I'm following with you 100% here. How do deadlines or pressure to sign influence how these agreements get accepted?
Many clients come to us with a severance offer in hand, and it typically has a deadline. And they're typically distraught not only because they've been terminated, but now they're suffering under a deadline, and they think, "Oh my God, if I don't sign on a dotted line, within whatever period of time the employer has dictated, that's it, the deal is gone." Well, remember what I just said. The employer is looking for something from you. They've put a value on it. That something is the general release. That value is not going to change by you going past the deadline. And although technically they can pull the severance offer, it's very, very rare that they will, just because you went past the deadline. And in fact, when employees come to us with a severance agreement and that we think is inadequate, and most of them are, we advise the employee, we're going to let the deadline pass because we're going to communicate to the employer that we don't care about your deadlines and we don't care about the pittance that you've offered in severance. We care about prosecuting the legal claims involved. And if you don't want us to do that, you're going to have to pay our client quite a bit of money.
And Gerry, what are some of the risks that someone might not recognize when reviewing a severance agreement?
Well, severance agreements sometimes, and that's why it's important, very important, that you consult with a skilled employment attorney, whether it's us or someone else. There are organizations that they can guide you to a good attorney, and most attorneys will give you a free initial consultation or at a very, very, minimal rate. So you should really, really consult with an attorney before signing anything. There are many risks in the severance agreement. Severance agreement could have not only a non-disclosure provision in there, but a non-compete provision that would keep you from plying your livelihood in the industry that you've just got separated from. Another thing is it might have in there what's called liquidated damages. So if you breach the severance agreement, you owe the employer an amount of money that's stated in the agreement. There are many, many tricks and pitfalls that are in those agreements, and that's why you really, really need to consult with an attorney before signing any such document.
And Gerry, you shared a couple of those tactics that employers might use. Might you have an example of a situation where a severance agreement had consequences the person didn't expect?
Oh, sure. A few weeks ago, a client came in, a prospective client came to us with a severance agreement that had a mandatory arbitration provision that they weren't aware of, that also had a non-compete provision that they weren't aware of, really, because it wasn't stated that clearly. It was stated just clearly enough to to pass muster in terms of the law, but not for a layperson to understand. So um, it's important that you really think very seriously about consulting with an attorney before signing any kind of severance agreement.
And Gerry, what options typically exist for negotiating the terms of a severance agreement?
Well, it all depends on the strength of the underlying legal claims. So if you have been the victim of discrimination, retaliation, harassment, if you're a whistleblower, if you think that you've been treated unfairly or differently on the job, then typically you'll have some claim that you could potentially bring in court. Now, the strength of that claim typically uh, dictates what amount of severance you should have. And in this sense, severance is really a misnomer. You're being paid to sever from the company, but you're really being paid to release your claims against the employer, and that's what the employer is looking for, as I've said before. You always need to understand that the employer is not going to show their hand right away. They're not going to give you the best deal right away, and they're just looking to protect themselves. They're not offering you severance in most cases just to be nice. They're doing it as a business decision to protect themselves. So the more risk you pose to them by having a stronger claim, having good representation, the more money you're likely to get in negotiating a better severance.
Gerry, I want to bring this home for our audience today. Can you actually walk us through the process for someone who may have been given a severance agreement? Where should they start? I know their first call should be to an attorney. If they didn't do that, how do they recover from that right now? Just kind of walk us through a scenario that someone might experience when they're in this position.
First of all, you need to be self-aware, and you need to understand that you're going through some form of PTSD. You are in crisis. You've been separated from your employment, and your employment is one of the most important things in your life. It's you spend more waking hours at work than anywhere else if you're working full time. So, don't make momentous decisions when you're in crisis before talking to someone. It should be an attorney, but even if it's not an attorney, talk to your therapist if you're having one, talk to your pastor, talk to your parents, talk to your friends, sound it out and see what it is exactly that is being offered to you. And try to understand that although you may feel diminished and disempowered by being terminated, you actually, in the context of negotiating a severance, have power because, again, they want that general release of your claims. And if your claims are strong ones, they're going to pay a fair amount of money for that, as long as you have good legal representation. Typically, we would, let me just say one thing. Typically, we, and no one case is like another, and there are no guarantees. But typically, if a client comes to us with a written severance agreement, and by the way, we're a pure contingency firm, but we don't take an interest in any amount of severance that the client has procured on their own. That's theirs. But let's just say client's making $250,000 and comes to us with a severance agreement of $50,000. We'll only take the case if it's a strong one. And if it's a strong case, that $50,000 is going to be multiplied up to a factor of 10 or more. It's the same principle in car accident cases, right? The insurance company, in settling your claim, is not going to offer you the most amount of money until you get an attorney and you threaten to sue. And then they'll ultimately give you what you deserve.
But there's some negotiation, and it takes a professional to do that. I want to wrap this up for our listeners today. For someone reviewing a severance agreement, not sure whether to call an attorney or just sign it and put this behind themselves, what factors should they weigh before making that decision to move forward versus calling an attorney and actually pursuing legal options?
I think they should look at as I said, how they feel, right? How they feel they've been treated. If they feel they've been done wrong, to use a colloquial term, let's just do that again. If they feel they've been done wrong, to use a colloquial term, and they feel that very strongly, they should examine why. And if the examination, let's do that again. They should examine why. And if the examination shows them that they were treated unfairly for a protracted period of time, they really should not give that up without consulting with a professional. If, on the other hand, they worked at a company for a month and the company experienced some kind of economic catastrophe and laid off half of its workforce, and they happen to be one of them, and the company says, okay, we'll give you a week's severance. Probably you don't need an attorney for that, because there's not a lot at issue. But if you're a long-standing employee and you have an inkling that what has been done to you by the employer is wrong, you should consult a competent employment attorney.
And I think we'll leave it there today, Gerry. Thank you so much for your insights and joining me for this conversation today.
Thank you, Lisa.
Folks, thank you for listening to Justice at Work, powered by Filippatos, PLLC. If you're dealing with workplace discrimination, harassment, or retaliation, or just want to understand your rights, visit philippatoslaw.com to schedule a consultation. And don't forget to like, subscribe, and share the show with someone who may need it today. We'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.